what's the best way that we can leave certain things to them to help provide for that education that won't negatively impact them in any way for like financial eligibility, for financial aid, things like that, and also just how will that be protected for them? How do we stop other people from disrupting that the purpose of that plan and leaving them an education fund? A lot of times too, people are concerned about if there's different children from a previous marriage, and if somebody passed away, how do we protect that for our kids? The kids I brought into the marriage who are, if I were to pass away, how do I make sure that their education is protected? So that's going to be the general topic for today, and talking about those that sort of education planning, and how you can leave that protected education fund for a child or a grandchild or just any family member for that. Doesn't matter if they're necessarily a blood relative or not, family or friend. So there's a couple of big things that I want to talk about in particular. Kind of what is accountable asset for what will count against someone's FAFSA application? What do they have to report on FAFSA versus what do they not? And how that can still matter even if you have them inherit in a trust from you. So a couple of kind of big things that we'll be handing out to you guys for those of you who are registered. We have a couple of checklists here. So one of the big things is a countable asset list for education and a non-countable asset list. And I'll kind of run through that with you guys today. Another thing too is we have a comparison chart here for you. What this goes through is just kind of the different types of educational accounts that people very commonly use to plan for college education or private tuition, but and how they, the rules behind them and how they can still impact financial eligibility, and maybe some of the drawbacks to some of them for planning as well. So what can be countable for a child's education when they have to report for FAFSA? So, a lot of people understand that, the parents' finances matter too. But when you actually leave a grandchild, for example, if you left them a trust to fund their education, it's not just that, you're leaving them assets. It matters what type of asset is in that trust, because they do have to report it for financial aid. So one of the big countable ones, obviously, is cash. If you leave cash to somebody, that is countable asset. It's available for their education. It can disrupt financial aid eligibility depending on their other requirements. Investments, stocks, bonds, CDs, a brokerage account of any kind, if that's left in a trust for a grandchild or a child and they are going into school, that can count against them. One of the big ones, and this is kind of one of the more common types of accounts you hear people bring up when planning about education for children or grandchildren, is a 529 plan, or an EdVest account, which is Wisconsin's 529 plan. Those types of things, they are specifically geared towards funding education, but they also, even if they were to be given to a grandchild once you've passed away, that is a countable asset, because the whole point of it is to be used for education. It is counted against financial aid as an available resource. So it can impact the amount they're getting from the school or from FAFSA, or the types of subsidized loans from the government, whatever it might be. What is non-countable, what they cannot hold against somebody trying to receive financial aid, is the primary residence of the family. So, if you're going to school and your parents just have the one home, they can't count that asset against you, because they're not expecting somebody to, borrow against their home or sell the home to fund their child's education necessarily. Now, additional properties, real estate across the state or out of state, or just anything in addition to your primary residence, that can be a countable asset. If the family owns a business and that business has fewer than 100 employees, small businesses essentially, those are not countable assets against a child for financial aid purposes either. The reason for that is understandable. They're not, again, they're trying to encourage people to be in business. They're not trying to encourage people to borrow against their business or cause them harm just to fund a child's education. Qualified retirement accounts is another thing. So when a parent is contributing to an IRA or a 401k, they may not even be able to withdraw from those accounts, without penalties anyway, early, depending on their age, um, for their child's education. So if they can't withdraw from those accounts, they can't be counted as available assets against the child's education because they just may not be able to penalty free, or and the government also does not want to encourage people to incur penalties on those retirement accounts. Life insurance policies is actually a really big thing that is not countable against someone. So one of the big tools you can use as you're planning for a child's education, if you're trying to do it through your estate plan, is to look at, okay, what type of asset can I leave them without it potentially counting against them for financial aid? And life insurance is a really, really good option for that. So you can actually take out a life insurance policy on somebody, and you can you leave that to them through their estate plan or your estate plan, and the cash value doesn't count against them. The death benefit doesn't count against them. So if you're trying to leave them, maybe the cash value of that policy, well, that's not going to count against them for financial aid purposes if it's inherited in a trust for them. And of course, personal possessions, things like that, don't count against you. They're not going to. Nobody wants to go through and value everyone's private property and their different family heirlooms and things like that. So you just don't have to report it at all. So there's kind of three big types of education accounts that you hear about in Wisconsin anyway. Some of them are very similar. For example, a 529 plan is a plan that you put in money, and it grows tax-free while it's in that 529 plan. But you have to use any withdrawal from it has to use for a qualified higher education expense. Anything that is not used for that qualified expense, which, just to give you an example, things like tuition, room and board, and then also if you're buying technology for school, if I'm buying a laptop to go to type up my notes in class, things like that, that can be a qualified expense potentially. If I just took money out of a 529 plan I had for myself, and I started buying groceries with it, or just anything else really, that type of thing, you not only have to then pay the income tax on the growth that has happened in that account since you've contributed the principal, you also potentially have to pay a penalty on that withdrawal. So that is sort of the drawback in some ways of those types of plans, is they are limited very specifically in what they can be used for. And the danger there is if you try to set up a 529 plan for somebody and leave it to them through their estate plan or your estate plan, not only is that 529 plan an accountable asset against financial aid purposes if they are going, applying for financial aid through FAFSA, but the big thing too is that it is also limited in how they can use it. And I do want to just let everyone know, if you are registered for this webinar through Zoom, you can submit questions and I will answer them as they come in. So the big thing there is just submit a question. I will, as they come up, I will try to get to them. Part of the point of this webinar is that it's interactive. So 529 plans, again, can be accountable asset, but they do have to be limited for what they are, for what the withdrawals are for. Otherwise, there can be a penalty incurred. There's no annual limit to how much you can contribute to a 529 plan per year. A lot of states do have their own maximum amount that's allowed in those types of accounts. What a lot of you may have heard of in Wisconsin is Wisconsin's state-run 529 plan called the EdVest account. That does have a maximum allowed limit in that account of $505,000, and that's the 2020 amount. It does get indexed for inflation every year. So that's still no annual limit for a contribution, but it is maximum amounts. Once you go over that, you can't put any more in. So that an EdVest account and a 529 plan, they're not mutually exclusive. They're not necessarily separate things. The EdVest account is a Wisconsin 529 So that EdVest account is subject to a lot of the same restrictions, the same higher education expense with withdrawals, things like that. One kind of caveats to that withdrawal is that it can be, you can take out a certain amount penalty free, assuming that they receive financial aid from another source. So, if there's a scholarship involved, say they got a $10,000 scholarship from the school, that you may be able to withdraw $10,000 or so from that 529 plan or that EdVest Wisconsin 529 plan without that penalty because you are receiving that financial aid from another source. One of the other types of accounts that we deal with occasionally through state plans is what's called a Coverdell account. Coverdell is a little different than a 529 plan. The big thing there being that it can be used for not just higher education expenses, but potentially private tuition, things like that, while someone is going to a private school. There is an annual limit, though, for those accounts of how much you can actually contribute per year, and that is currently about $2,000 a year. So it is limited, and any time that you contribute that amount, you can potentially be limited further if your adjusted gross income is over $110,000 for a single filer, or double that if you're married. $220,000 is after that point you can't contribute to a Coverdell account anymore. With a lot of these accounts, the danger you run into when you're planning for somebody to leave these accounts through an estate is that they are very heavily dependent on the fact that you're expecting someone to go to school. Essentially, they have to be used for that. Otherwise, they will incur penalties if they use them for other things, or have to pay income tax on the growth. So it's not necessarily ideal if you're not sure that somebody is going to go to school. So that's where you can look at planning through your estate and kind of talking with not only a financial advisor, someone who specializes in maybe planning for college up front, college expenses, but also talking to an estate planning attorney and saying, here's my goal. Here's what I'm trying to do. I'm trying to leave a certain amount of money for someone I care about to use for education expenses. And that is where your sort of financial advisor and your attorney can get together and say, okay, well, here's what can count against someone for financial aid. So that's one consideration. But also we want to look at, are you sure that child or that grandchild is going to go to college? Is higher education their goal? And it actually isn't a big, or it is a big question for a lot of people. Not every child does want to go to college, or maybe they have other goals. Maybe they want to go to trade school, something like that. Which is a totally acceptable option for a lot of people. And that's but for that, you might want to do other financial planning for them then. So one of the common questions is, what should I do if my child, may want to go to school, may not want to go to school, but I still want to put aside money for them? Well, that's where you can have your estate plan state, here's the amount of money I want to leave them. Maybe I want to leave it to them in a protected manner, so that if they have creditor concerns, or they, divorce concerns, or maybe medical liability concerns, something like that could impact the amount of money you're leaving them for that education, you can make sure that it's not available for those resources. So that's where you can have someone, a beneficiary, a child or a grandchild, or really anybody, inherit in an asset protected trust share, where they're saying, okay, if a creditor, could come against my own money, but I still am trying to go to school, well, the money that my mom or my dad or my grandma or grandpa left me in this asset protected trust is not available for those creditors. So I can have that available if I want to go to school. But the added benefit too is, depending on the types of assets in those inherited trusts, for example, if it's not a 529 plan, but maybe it's an investment account, or an inherited IRA, or just any type of cash asset. Well, then if it's not a 529 plan, if it isn't a Coverdell account or an EdVest account, you don't have to necessarily use it for education. So you're sort of giving them then the leeway to decide how to use that money if they aren't looking at higher education. that in particular with 529 plans, that's kind of the danger, is because it specifically says higher education expenses as a qualified expense. That's a little limited. It's not as broad as some other tools that you can use for them. So that's a really good option. As I mentioned, life insurance is another really good option too. Because life insurance is not a countable asset for financial aid. So if they do want to go to school, you're not potentially harming them by leaving them that amount and saying, oh, well, that's going to kick you off of your financial aid, or, now you're going to have to take out a lot of student loans. But, if they do want to go to school, then they can use that cash value later and sort of as a way to pay down student loans, or to just use it for other expenses that they wish without causing them harm. So one of the big things too is in blended marriages, that can be a concern, because in general, there's a lot of concerns that people have with blended marriages, or blended families, excuse me, where they bring in children from a previous marriage. The big thing being, well, if I pass away and we have joint planning and all of that, how do I make sure that my kids are taken care of? How do I make sure that if my spouse gets remarried, that they don't disinherit my children? And there's a lot of planning you can do especially through trust planning, where you're saying, upon the first of us to pass away, here's what happens. Some amount goes to, maybe my kids, or to the surviving spouse, or it goes all to the surviving spouse, but some of it is kind of limited in what the surviving spouse can change about it. There's ways that you can prevent the surviving spouse, and this is something that both spouses would have to agree on beforehand, obviously, but you can limit what the surviving spouse can change beneficiary-wise. So it might be that during the surviving spouse's lifetime, they get to use the income and principal for their own benefit. But if they are trying to change who the beneficiaries are on those, maybe on those accounts or on that side of that trust, they can't do that. So you're protecting that amount of money for those other beneficiaries, making sure that remarriage does not get in the way of your assets going where you want them to. So with grandparents, the big thing being that tends to be the more common age where they're trying to plan for people currently going to school in their estate plan, just because most parents, when their children are going to school, they tend to be more not concerned about what happens if I suddenly pass away. I mean, it's certainly something you still want to plan for, but with grandparents, it tends to be a more common concern, I would say. But with grandparents, you can set up these types of accounts for your grandchildren. I mean, anybody can, set up a 529 plan for a beneficiary. They just designate the beneficiary of that account on there. So a lot of times that's where grandparents do this planning, trying to plan for their children, or their grandchildren, excuse me. And that's where it's really important to talk to a financial advisor, and it's really important to talk to your estate planning attorney and saying, okay, here are my goals of where I want to leave this sort of education fund for my grandchild, but I'm concerned about financial eligibility for them, or I don't want to cause them to be in more debt because they had to take out more private loans, or more subsidized loans, or whatever it might be. So that's where you really want to look at what types of accounts are you leaving them, where that 529 plan would be a countable asset versus a life insurance policy, for example. Another thing to consider, and this is more so for parents, whose kids might be younger currently. When you have children and maybe there's a pretty decent age gap between them. So, say at least a 2 to 3 year age gap possibly is kind of standard for a lot of siblings, right? Well, there's planning you can do to make sure that they sort of receive equal support from you, and that they have that equal access and equal opportunity to use their inheritance for education and have that support from you. So just to give you a description, I'm 2 years older than my brother, for example. And if I had, my parents had passed away and I was already in college at the time, when I had first started, my brother was still in high school. At that point, I would have gotten 2 years more of support from my parents, just from them being alive and potentially, helping me with school and just in high school, covering me with certain expenses than my brother did. He would have gotten 2 years less of support from me and therefore gotten less money. So if all the estate plan says is, well, they get equal shares. So if both parents pass away, they get equal shares, 50-50. If that younger child is still in high school and the older one's gotten some support from their parents, they have to use less of their inheritance for their education than the younger child does, because they just haven't had their parents around, for as long in their life as their older sibling. So there's a lot of really good planning you can do for that in your estate plan. What we often use for that is what's called a common trust. So that's where you're saying, when the survivor of me and my spouse pass away, I don't necessarily want my two children or however many kids, I don't want them to each get their own share right away. I want to put some limitations on when that happens. And, kind of to give you a common example with that, one of the big things is saying, until the youngest turns, let's say 22 or has graduated college, you can put those types of restrictions on it. So in this instance, saying when the youngest has turned 22 or has graduated college, what you're doing is you're setting that bar of saying, okay, at that point, they've all received equal support from our estate. And at that point, they get their equal shares, because then, we've taken care of each child the same amount. And from that point on, it's up to them what they do, or whatever other restrictions you might have placed on it. And that really protects children, especially with a bigger age gap. Not as common, certainly, but if you had potentially a 5 to 6 year age gap, the oldest is going to have had a lot more financial support from you than the youngest if you were to suddenly pass away, and the youngest was just about to go into school, for example. You don't, if your goal is for them to inherit equally, the common trust really ensures that happens when you're dealing with educational expenses. Because otherwise, if you said, I want 50-50 to each child, each of my two children, well, they initially get that 50% split. But if the oldest has already had financial support from you through college and the youngest hasn't, well, that's not really 50% then, because the youngest is going to have to use more of their inheritance towards that same education expense that you had already covered for the older. And quite frankly, this is something that it's not just parents setting this up. Grandparents, again, can set this up if they're specifically leaving something to grandchildren. And they said, well, we want to specifically include our grandkids in this, and we have a pretty wide range of grandkids age-wise. So that's something as well that can be put in there. But a common trust is a very, very good tool that you can set up for your children to make sure that they get the equal support from you for education. And with that, again, the types of accounts in there may be important to consider, 529 plans, things like that. Maybe you just leave an investment account in there. That kind of thing. But again, it's really more to make sure that it is truly equal, if that was your intent. Again, maybe your intent isn't for it to be equal. Maybe you decided specifically that I don't want to, I know my oldest didn't go to school, so I'm not going to worry about that for my youngest, or, in terms of trying to equalize out that support. And that's a discussion you need to have. It's not necessarily right or wrong. It depends on your situation and on your goals. This is something, again, that you just want to talk about initially. So just to kind of give you an example, the average cost of tuition for 2019 and the 2020 school year, for example, this was in-state, is about 11 to 12 grand for tuition for public schools for residents. For out of state, it's quite a bit more. It's roughly $27,000 to $30,000 a year. Private schools obviously are automatically more expensive, whether you're in state or out of state. A lot of times, you're looking more at $40,000 to $50,000 a year. So this type of planning in advance is very, very important to set up, because if you left $100,000 to each child, and you had already paid for the oldest child's school, well, the youngest is going to potentially exhaust that inheritance a lot sooner if they are still in school and paying for that tuition. So it's something to talk with a financial planner about, looking at the best types of accounts to set up for that type of planning, and having them work with your estate planning attorney and say, okay, here's our goal for what we want to leave our children. Here's what we want to provide for. what's the best way to do that in terms of the type of planning we do. And, then, for example, I would work with a financial advisor and say, they're your financial advisor, and say, okay, what types of accounts do we have set up, and what do you think is best for that type of, financial goal? So it's something that, there's a lot of different moving parts, obviously. So I will again just remind you, if anybody has any questions, please, you can submit them now, or if you comes up later, please let us know. You can email, send us an email, or give us a call, and for those who are registered, you will be receiving a survey feedback form of types of topics you might want to hear from us in the future, or if any of this rings true to you in terms of concerns you might have for your child's education or grandchild's education, I encourage you to give us a call and set up a consultation. We do free initial consultations, so it doesn't cost you anything to come in and initially ask us some questions on some things. If you didn't register, you can always reach out to us as well. You can go to hooperlawoffice.com as our website. We have a lot more information on there too about general estate planning advice, and contact information if you would like to set up an appointment. The next webinar that we have coming up is on August 19th. So that is next week. And what we're going to be talking about then is really creating a legacy, an education legacy for your estate plan. So whereas today we were talking a lot about, how you can plan for individuals that you want to, leave an educational fund. What we're going to be talking about next week is more on the charitable side of things. Do you want to leave money to a financial institution, or excuse me, to a educational institution, or do you want to set up some sort of scholarship fund, whatever it might be. So that's what our topic is going to be next week. So if that interests you at all, please register at estateplanninglive.com is where you can go to register. If I don't get any other questions here, I'll close it out for the rest of the day. But again, if any of this concerns you, or you do want to have a discussion about how best to do this type of planning, please reach out to us. We're happy to help where we can. Well, doesn't look like I have any other questions. So with that, I will sign off for you guys, and have a good rest of your day. And I hope to see you guys next week.